I want to thank you all for participating in the Friel Scanlan lecture today. It truly is an honor to give this talk, and I'm very grateful to the law school. I received this honor in the spring of 2019, so I'm a little bit late in giving this lecture, which should have been in the spring of 2020, but world events intervened, and I've been a little tied up since then. So thank you for your patience, but I'm delighted to be here, and I'm delighted to share this work with you. Before I do, a special thank you to Nicole Regis Eisenstein, Amber Bethune, Book Schneider, and Colleen Trimmel for all their work in inviting you here today and communicating about this event. They've really done a terrific job, and I want to thank Linda Irwin for supporting those efforts. I also want to thank Sean Nair and John Beam for supporting this webinar and their technical support. And finally, a thanks to Jonathan Lipson, who has been my comrade in contract law. Our work on contract law after COVID informed this project, which was published in the Washington University Law Review. So I guess I'll start kind of zooming out and watching the tragic and alarming events unfold in the Ukraine. One consequence that has received some but much less attention is the war's effect on surrogacy arrangements. The Ukraine had become a destination for gestational surrogacy services, but with borders closing, intended parents were unable to travel for the birth of infants born to gestational surrogates. As a quick background, gestational surrogacy is when a person undergoes IVF to become pregnant and the resulting children or child has no genetic relationship to the surrogate. Traditional surrogacy, as it's called, on the other hand, is when a surrogate donates genetic material, an egg, to a resulting child. And here, our focus is going to be on gestational surrogacy. But with borders closing, intended parents were unable to travel for the birth of infants. So think about the US couple who walked across the Ukraine-Poland border to pick up and to bring back home an infant born to a gestational surrogacy. And without minimizing the devastation of war, the pandemic, like conflict, has upended the expectations of parties to gestational surrogacy contracts. In the wake of the spring of 2020, news stories documented the makeshift care arrangements as intended parents struggled to enter the countries where births had occurred. That was true for surrogacy in the United States. The example of an employee of a Chicago-based surrogacy agency that cared for 2 infants for more than 5 months, while the intended parents from China waited for travel restrictions to abate and for the visas and passports needed to enter and to leave. So in the United States, which is also going to be our focus today, several states have passed laws that purport to represent the best practices in surrogacy regulation, focusing specifically, as I mentioned, on gestational surrogacy. From Nevada to Maine, states are repealing prohibitions and regulating surrogacy contracts in fairly patterned ways. For example, by requiring mental health counseling and legal representation for parties. Scholars and practitioners alike herald this legislation as the way forward in protecting the rights of interest of both intended parents and surrogates, and to bring back in the international context while other countries are cutting back on the practice, not allowing payments to surrogates beyond compensation for expenses, allowing use by intended parents from their own countries or prohibiting it entirely. The United States, by contrast, is moving in the other direction. More states authorizing surrogacy and enforcing surrogacy agreements, and more states authorizing commercial surrogacy, with only very few putting residential restrictions on who can use the process. So my focus today is on some of the most controversial terms of surrogacy contracts, those governing prenatal behavior. And I'm focusing on prenatal behavior to show how fertility professionals mediate recurring tensions over who controls prenatal decision-making. Intended parents want authority to make decisions regarding pregnancy, and fertility agencies and lawyers cater to that desire, supporting the broader assumption that parents should seek as much prenatal information as possible. Once pregnant, however, surrogates as patients exercise control over that information. Surrogacy arrangements rarely result in litigation and rarely end with parties abandoning the agreement. But evidence also suggests that disputes over managing the pregnancy routinely arise. So how are those disputes settled? The language of the contract is not much help. A clause mandating a surrogacy submit to prenatal testing will precede a provision guaranteeing the surrogate the right to make all healthcare decisions. State statutes similarly contemplate some control for parents and some protection for surrogates. And courts have not stepped in to resolve a number of uncertainties. In some, it's frequently unclear whether surrogacy contracts and terms governing prenatal care are legally enforceable. If those terms were enforceable, what the remedy should or would be. And even if there was a remedy, say compensation for intended parents for the fees they've already paid, whether a party could actually collect damages from the other. My work draws on theories of relational contracting to suggest why parties comply with contract terms that are likely not enforceable and to describe how parties resolve disputes. Relational contracting is a strand of contract law literature that demonstrates how non-binding agreements are nonetheless adhered to by parties because of the reputational loss occasioned by perceived breach. The reputations at stake are not the parties, but the legal and healthcare professionals who are repeat players in the field. I demonstrate that lawyers, in drafting the contract and then implementing it, help build the trust and relationship between parties that induce compliance with largely unenforceable terms. So when there's conflict, fertility professionals diffuse it. I also identify some consequences of relational contracting and surrogacy, from obscuring bias to entrenching the power of fertility agencies. So in my time today, I want to make 4 points to inform our discussion. First, I will provide an overview of surrogacy regulation, providing a background on contemporary legal developments and focusing on how state laws treat terms governing prenatal care. Second, I'll describe how lawyers and health professionals facilitate compliance with surrogacy contracts in practice. Third, I'll reflect on a few consequences of how agencies and lawyers traditionally have managed surrogacy disputes. And then finally, I want to describe how contracts reflect issues stemming from the pandemic, specifically related to vaccination, and why those COVID provisions are emblematic of larger, long-standing debates. Okay, so first up, the role of regulation. There is a spectrum of permissibility setting out the context and enforceability of contract terms. So let's take the laws of 3 states, our state, Pennsylvania, our neighbor, New Jersey, and Arizona. Arizona is by far an outlier. It is one of 3 states in which surrogacy contracts are unenforceable. Arizona law does not punish people involved in surrogacy arrangements, but it will not enforce a surrogacy contract, compensated or not. However, per a case decided in 1994, intended parents routinely petition Arizona courts for an order declaring them the legal parents of a child born through a surrogate out of state. And Arizona attorneys write memorandums of understanding that are not legally enforceable, but get parties on the same page about issues like prenatal behavior and prenatal testing. In addition, lawyers counsel intended parents to partner with surrogates that reside out of state, and many intended parents rely on agencies located elsewhere in the United States. So even though the law on the books would suggest restriction, in practice, surrogacy thrives in Arizona. On the other end of the spectrum of what law says is New Jersey. A few years ago, New Jersey passed the Gestational Carrier Agreement Act, which reflects national trends in the legislation governing surrogacy. If a surrogacy contract meets the requirements of the act, the contract is presumed valid and enforceable. The act requires that both gestational surrogates and intended parents have mental health counseling before the pregnancy. Both surrogates and intended parents must be represented by attorneys, though parents may pay for the surrogate's lawyer. The surrogate picks her physician after consultation with the intended parents, and the intended parents must take legal responsibility for any resulting child or children, regardless of the number of children born or physical genetic characteristics of those children. They must also, under the law, pay all reasonable expenses. So somewhere in the middle of New Jersey and Arizona is Pennsylvania. There's no statutory guidance and a smattering of court decisions upholding surrogacy arrangements. And there's a slice of states that look like us, that permit surrogacy, but do not regulate it as closely or as explicitly as a state like New Jersey or New York. Pennsylvania is interesting because it's the Department of Health, not the legislature, that has issued regulations for listing intended parents on a child's birth certificate. So even without statutory protection or guidance, surrogacy still thrives. Despite these legal differences, you'll find that gestational surrogacy contracts written anywhere in the United States contain very similar provisions. And that's because there is a proliferation of form books and boilerplates and guides. Contracts include choice of law provisions, and often cross-border operations are managed by large national or regional agencies. So given the continuity across contracts, are surrogacy contracts or some of their terms, especially governing prenatal decision-making, legally enforceable? Often not. So consider the list of behaviors that surrogates frequently pledge to abstain from in their contract. No alcohol, no strenuous activity, no manicures, no sexual intercourse in the third trimester when there's no possible confusion about a genetic relationship. The list goes on. So if a surrogate does CrossFit or a nail treatment, would a court deem the provision enforceable, and what would be the remedy? Under the New Jersey statute, the surrogate retains the right to make all healthcare decisions. A prenatal behavior clause seems to contradict that right, so perhaps the clause is not enforceable. But the statute doesn't say anything about terms governing prenatal behavior, and some state laws explicitly permit surrogacy contracts to govern prenatal choices consistent with the professional guidance issued by the American Society of Reproductive Medicine, a leading authority on the matter. So let's assume that a prenatal behavior clause is enforceable. What's the remedy? Most state laws allow any remedy at law or in equity. However, courts will not enforce contracts requiring specific performance of a prenatal behavior or medical decision. Intended parents could ask for damages if a surrogate did not comply with a prenatal behavior clause. The contract can even stipulate damages. But when should they collect? During the pregnancy? That's risky for the relationship between the parties. After pregnancy, there are challenges of collection as well as how you would calculate damages. In some, terms in surrogacy contracts frequently contain conflicting provisions and contradict state law. This leads to the second point I mentioned at the outset of my talk. If provisions contradict each other and may cause conflict between the parties, why don't more arrangements fall apart? Because based on the evidence we have, most arrangements hold. My answer: intermediaries like lawyers, who are often connected to agencies, keep the relationship together. Few legal academics have tried to assess the practice of modern surrogacy contracting, and that's because it's really hard to do. Contracts are confidential. Agencies and other industry actors have no duty to collect or disseminate data. Practices vary based on law, place, and person. So I gathered information across the country to try to piece together a picture of what's happening, but I also rely on relational contracting to argue that the process of negotiating and signing a contract and the relationship established in that process is the glue that makes many surrogacy arrangements stick together. Contract formation aligns with the interests of intended parents who seek to exercise the maximum amount of control tolerable to the surrogate. And lawyers intervene after a contract is signed because power shifts. The pregnant surrogate will receive care from an obstetrician. That care, in theory, is aligned with her interest as a patient. So said another way, before pregnancy, lawyers, often through agencies, work to get the parties on the same page about how prenatal decisions will be made. During the pregnancy, lawyers, to use their term, triage disputes over that prenatal information, which the surrogate controls. The relationship between the parties encourages them to comply with the contract, sometimes because their interests align, sometimes because they believe the contract is legally enforceable, even though it may not be, or sometimes because they want to preserve the relationship that's already established. And qualitative studies of intended parents and surrogates' attitudes support that last point around relationship preservation. So that brings me to my third point. In the surrogacy context, legal professionals and fertility agencies manage the process, and that deserves greater scrutiny. Without intermediaries, conflict over prenatal control can escalate. But I want to highlight three potential consequences of intermediaries' role in resolving disputes in surrogacy arrangements. The first is invisibility. The work of fertility professionals can shield from view people's biases and bad behavior. How often do disputes arise? How often do parties breach contract terms? For example, how many surrogates don't get paid what a contract promises? It's hard to know. And in that vein, we might be worried that conflict is being suppressed rather than resolved, and with it, behaviors potentially rooted in subordination and stereotyping. Second, expense. Dependence on legal and health professionals increases the cost of surrogacies. So if you can afford lawyers and counselors, you'll likely purchase expertise in conflict management. Fertility health services specifically are stratified by race, income, and region. This, of course, corresponds to the unequal distribution of health services across the United States generally. But low-income people of color have disproportionately high infertility rates and yet are frequently unable to pay for IVF or surrogacy services. Third, scholarship on this topic makes assumptions about the bargaining power of the parties, but ignores the role of industry actors. Parties do not occupy fixed positions. The surrogate taken advantage of, the intended parents always in control. I think those dynamics occur. There are clearly income differences between surrogates and intended parents, though the research shows the gap may not be as deep as many would assume. But I think the picture is more complicated because of the relationship that develops between parties and because parties have different bargaining power at different stages of the arrangement. As I mentioned, before pregnancy, intended parents drive the process through reproductive endocrinologists and counselors who cater to their needs. After pregnancy, the focus shifts through prenatal care delivered by an OB who has a duty to the surrogate. Exerting power over the entire process are fertility agencies, which have grown in size and reach. The success or failure of an agreement affects agencies and brokers' reputations. Agencies thus have incentives to make contracts work. Agencies have already required counseling and representation in their own policies before many statutes did. However, we might worry that some agencies' interests may not always align with those of the parties. Indeed, the veneer of altruism that has historically characterized surrogacy can obscure the interests of a fertility industry that is largely unregulated. So fourth and finally, recent changes in contracts in response to the pandemic spotlight how gestational surrogacy works in practice. So I reviewed 70 websites, online information of national surrogacy agencies. I picked the agencies that have reach across the country, which is typical now of how fertility agencies operate. The evolving nature of pandemic-related information and the need to reassure clients made visible agency practices that had otherwise been obscure. So the pandemic was a moment in which agencies were putting information on their websites and online portals in order to attract surrogates and reassure would-be intended parents. And it's worth emphasizing that the growth of surrogacy agencies, which are increasingly large entities that operate across the country, as I mentioned, are large because they serve as hubs for legal and health services, often with in-house counsel, partnerships with healthcare providers, case managers on staff. So at the beginning of the pandemic, agencies were posting advice about travel restrictions, COVID safety protocols, and hospital rules. However, as vaccination took hold and vaccination status took center stage, and this is developed in a couple of different ways. For one, agencies include vaccination status as part of their eligibility requirements. This is on the back of CDC and professional organizations' guidance, like the American Society of Reproductive Medicine, which I mentioned earlier. For another, agencies have sought to match intended surrogates and surrogates based on their vaccination beliefs. And that cuts both ways, with some intended parents seeking vaccinated surrogates and others seeking unvaccinated surrogates. So beyond matching and eligibility, contracts are a tool for managing the expectation, and agencies have taken on a role in enforcing those expectations. So let me offer the example of the bad cops by Creative Family Connection. That's a descriptor from a detailed explanation of Creative Family Connection's COVID approach. It's a video I can put in the link during Q&A on YouTube that I recommend you watch. So this was a presentation by CFC, which is a very large gestational surrogacy matching agency that had a reproductive endocrinologist, a case manager, the executive director, a pregnant gestational surrogate, and an intended parent that had used Family Connection services previously. And it was a video to reassure potential intended parents and potential surrogates about how Creative Family Connections would intervene in light of vaccination conflict and worries about COVID safety. And in a really telling part of the video, responding to a question about potential disagreement about how to take the right COVID precautions, the executive director responded, "You, the intended parent, are her, the surrogate, cheerleader. You let us be the bad cops. If you think there's something that needs to be told in a sterner fashion, we'll do it. We never rat out the parents. It comes from us." So there's a lot more to say about this, why the Creative Family Connections approach is indicative of what I saw across these 70 organizations. But I just want to make two brief reflections in taking this snapshot of a particular moment. The first is that prenatal control and the will to exert control over prenatal information and decision-making is the norm. It's not the exception. And COVID shows that very clearly. So, again, consider the typical abstention clauses found in many contracts. A wonderful sociologist, Hilary Burke, that's at UC Irvine, details in her review of hundreds of agreements. Contracts routinely require surrogates to, quote, and this is from the boilerplate language that shows up in lots and lots of contracts, consume solely organic food and supplements while prohibiting caffeine, sugar, fast food throughout the pregnancy, prohibit engage in activities like acupuncture, going to the gym, microwaves, hairspray, or changing cat litter. So prenatal decision-making, as well as access to prenatal information, which we could talk about a little bit more, norm, not the exception. The second is the idea of surrogacy as an exchange rather than an altruistic act. There is a lot written about surrogacy either as commodification or as compensation, much of that written by feminist legal theorists who have disagreed about what is the nature of surrogacy vis-a-vis commodification of pregnant people's reproductive services. But here I focus on something a little bit different, and that is how COVID provisions test the assumption, as has always been the case, that surrogacy services are like gifts or duties owed to family members. So think about how COVID tried to entice surrogacy compliance with COVID protection measures. Groups like Creative Family Solutions did it through additional compensation. So that group, as others, for instance, offered stay-at-home stipends, $500 or $1,000 for surrogates who completed various parts of the surrogacy process remotely. So my point in raising this is to, test the idea that is permeated much of the literature on surrogacy about it having an altruistic nature, to suggest that we might focus on what would give surrogates more leverage rather than focusing only on articulating their statutory rights. By thinking in terms of altruism, we might take away the power of surrogates to ask for more. So we might ask, what are the points of leverage? How might regulation intervene to increase that leverage? So I'm running out of time, but I'll end by just saying, what's the way forward? One, we might resist COVID exceptionalism. This tells us a story and tells us something about how the fertility industry works and how it can adapt. And my tentative suggestion revolves around challenging agencies' dominance and opening access to fertility markets. But I'm interested in your thoughts and reactions, so I'll stop there. Thanks so much. Questions or reactions?
Well, this is sort of a broad one, but I tend to look at so many phenomena of concern like this in these days, in where there seems to be sort of a room for regulatory action to truly protect people and to untangle things, as further examples of sort of supine acceptance of the capitalist imperative, and sort of a kind of emerging cultural belief that, like, whatever somebody wants to do with the contract, whatever somebody wants to do with the shrink wrap contract, whatever somebody who starts a business wants to do is sort of what they get to do, and it's not for the collective to intervene. So I suppose this just seems such an interesting example of something that is really it is a strange area for a market to exist right off the bat. I mean, it's right in the center of family and procreation. It is sort of structurally and obviously prone to forms of abuse and chicanery. And yet it's kind of just been allowed to percolate along and largely governed by contract, or at least it doesn't seem like there's intensive regulatory scrutiny. So I suppose I'm wondering, do you have thoughts about, sort of the larger political economy element of this story and how it fits more broadly into reproductive health and health regulation generally?
It's a great question, because there may be a little bit more background to tee up what can only be a partial answer. So the United States has a really interesting history as it relates to surrogacy, and I think that's why I'm so interested in the altruism veneer, because we began from a place of baby M, where states were forbidding surrogacy because of the threat of reproductive exploitation. And baby M is the iconic case in which a court struck down a surrogacy agreement as void for public policy because of, and it didn't involve a gestational surrogate, it involved a traditional surrogate who had donated her egg and then sought to retain custody of the resulting child, which the court awarded, naming her the legal parent, in addition with the father who had donated the sperm. Baby M is a great case to teach in contract law, but it absolutely now is anachronistic of how the US surrogacy market looks, because what started to happen is the rise of gestational surrogacy and the proliferation of IVF as a way in which to meet fertility needs. And, as that market grew, states began to soften their laws and court decisions started to wrestle with the question of parentage and who is legal parentage. And there was a convergence of both the uptake of fertility service and the desire for them, with courts confronted with these questions of, well, then who is the legal parent? This isn't a baby M case. You know, there's a gestational surrogate who's had no genetic relationship to the child, and two parents that, you know, one or both do. And so I think that teed up a conversation and really set the stage for then the next wave of legislation that said, well, so long as surrogates are being paid, then it's not exploitation, right? It's not selling organs, receiving money for your organs, or, you know, the kind of markets that, as Scott alluded to, we tend to say, oh, no, that's a public policy problem, to have a market in organs or babies or people for very good reasons. As the genetic connection became, you know, more distant, and as IVF proliferated, courts started talking about these surrogacy arrangements in terms of altruism. So long as they weren't compensated, so long as you were just paying expenses, the case law, as well as the legislative history for you know, the kind of generation back of statutes and the like, on every website for surrogacy service that you'll read, it's all about giving the gift of life. You know, Mike Pence was just talking about how he received the gift of life through surrogacy, and it was the most courageous and, you know, act of love. And there was intertwined in the permissibility of surrogacy this idea that it wasn't exploitation, and it wasn't, you know, fair market principles. It was this family formation that was based on these acts of altruism. And that has started to give way in some sense, but you still see it in this new generation of legislation, which is very pro-contract, at the same time being very pro-surrogates' rights. So the New York was one of the last holdouts in granting legal permission. It's the only state that has a surrogates' bill of rights, at the same time that it has all the same language about recognizing contract and contract terms. So this is a long, long, long way of saying that there's been an exceptionalism kind of carved out in this space to try to treat this not as a healthcare bought and paid for, but as a type of relationship that forms around family formation that has this sense of not just economic exchange, but of altruism. And I think that that's really played very nicely into the narratives that fertility agencies offer. They're not businesses, they're not brokers, they are relationship formers, they are, and I think it's really complicated business. I think that, you know, I think a lot of folks do think about the roles of agencies in that way. I think agencies and lawyers believe they're doing work that is not just about, you know, a commercial exchange, that they are doing something much more significant, something much more weighty. But my fear is, to Scott's point, is that it obscures, especially with a fertility agency market that has ballooned in the last 5 to 10 years, and that's been unregulated at the state and national level, that narrative obscures how the fertility agents really are part of markets. They really are part of economic exchanges. And I worry that when we don't think of this and it's as a capitalist project, then we obscure who wins and who loses, because we're not seeing it, in part because of industry practices, but in part because of how we think about the area itself. Sorry, that was long, but I'll try to be. Jenny Dodd.
Hi, thank you for your remarks. And also I have to thank Dean Smagula, who invited me to this talk. I'm very interested, as I'm a practitioner in New York City and trying to develop a surrogacy practice. And I just attended the third annual International Surrogacy Conference in Copenhagen. And all of these points that just were raised it's a constant debate. And I'm very interested and would like further for you to further expound on this idea that the gift part of it, that the altruistic part of it is actually obscuring and probably to the detriment of those most in need of protection that regulation could actually bring. And I find that really fascinating. And I think it's a really amazing perspective, because all I hear from other practitioners, and I'm very new to this area of practice, is that, oh, our surrogates want this and our surrogates want this. And they feel they in terms of parentage, because that was another big issue that came up, is like, who should be recognized in which way, and to whose benefit. Because I think that we spend a lot of time thinking about the intended parents' rights, a lot of time thinking about the surrogates' rights. Now that's become part of the forefront. Definitely the New York law is really forward thinking on protecting surrogates' rights. But we also have to remember that the child has rights as well, and to know their origin story, right? So that's just an aside. I'm sorry, I'm like rambling because I'm excited about the topic. But this idea, in New York, some of the biggest players who were against our law were the feminists, who really tried to prevent it from being passed. And I think that this idea that it sort of plays into the whole narrative of women give things that other people value. And that is to their detriment. And if there was regulation over this area, maybe women would be more protected. I went over a lot of things there, but maybe you can pull something out of there that made sense that you could talk about. But
sure, no, those are great comments. Thank you for coming, and would be excited to talk to you more about what's happening in New York. It's such a fast changing. I don't seem to be able to write about anything that stays still. I need to become like a historian. And so like, it's like I need to take a page from Greg Green. but that too is contested and changing. So I can't even say that. So I love so what I think that, as you say, I think that there's a lot of forward-looking thinking in the New York statute with the Surrogacy Bill of Rights. And I guess I'd say in response to your comments that the disconnect between trying to protect both intended parents and surrogates through these statutory sets of rights seems to me an important step forward, to be explicit about the rights to govern your own health decisions and the right to make medical decisions. But my worry is that what gets left out is any oversight of the entities that actually match people, then govern their relationships, push their relationships forward, and diffuse conflict and make sure that relationships stick. And so, in a sense, to your point about altruism and the what it might obscure, that's part of the same problem, and that statutes are very well-meaning in trying to think about where intended parents might want control and information in a process that their at points are going to be largely out of control of, and where surrogates are going to need reassurance that intended parents can't go too far in trying to exert that control. But it doesn't say anything about how those rights get enforced when there's conflict, when there are these entities that are the consistent intermediaries. And I just think thinking about their role as intermediaries would shine a lot of light on what bargains are worth it and what are not. So to your point, another point that you made, I think you're right. The language around surrogacy is replete with ideas of altruism and of giving a gift. And I think that what I think that obscures for me is the problem of being able to bargain for financial support or other in-kind exchanges that might be worthwhile for an intended parent for certain, for certain like vaccination status or the like. So I know you covered a lot of ground, but I'm very happy to talk to you offline. Thank you. Paul Guliuta.
Hey, this is a great talk. So I think my question or questions, they build a bit both on Scott's question about how the commodification of surrogacy is sort of situated into, the U.S. approach to healthcare more broadly. But I think it also touches a bit on Jenny's comment about the political autonomy of surrogacy regulation. But I sort of want to try to bring those two considerations together from almost like a federalism. So, you talk a lot about how there's, a lot of divergence among the states about whether they permit gestational surrogacy and in what circumstances they do, if so. But then you also describe, this national and I guess probably even international market for surrogacy services. So, this seems like the sort of commerce that might be regulated by the federal government. And, obviously like the knee-jerk response is like, well, those clowns in Congress can't do anything. But here, right, you have sophisticated surrogacy agencies that operate across state lines. And wasn't clear to me like whether there would be an equally powerful political interest that might oppose them. So, have surrogacy agencies sort of tried to start chatter about federalizing surrogacy law, or anyone else started chatter to that end? If so, what might a federal law of surrogacy look like? If that hasn't been floated, I'd be curious to know why. And then relatedly, at the state level, what are the political forces that push state laws in such different directions, right? I know that the focus of your proposal is kind of on strengthening the bargaining power of surrogates in the market, but I'm curious whether either a federal law or uniform state law or anything like that, might be a possibility as well.
Yeah, thank you. Great. So there have been proposals for a federal law to try to set a national framework for balancing the rights of independent parents and surrogates. It hasn't gotten very far, not because of resistance by the industry necessarily, because there's a presumption that any federal law would be permissive, that it would try to aid and encourage gestational surrogacy in the US market. I think the nascent fear is that it would go too far in trying to reach into state practices and the like. But there certainly have been those proposals. The obstacle, as you note, is that it's bound up in a number of things. Family law, the practice of medicine, those have typically been under state police powers and state reach. And there's been resistance at the state level for having the federal government try to impose a national standard for states that disagree. So would that mean that Arizona had to allow recognition of surrogacy agreements? Would the legislative framework offered in a place like New York be compliant with the federal framework? I think that most what people hope for is the type of general legislative guidance at the federal level that could be best practices, but not necessarily a national right to surrogacy, which is how it's often framed, which is a great question given the current legal and judicial landscape, because there has been very little momentum to create a national right to surrogacy. And the answer why is probably obvious to any of you that have followed the abortion debate. The inroads of a national right to reproductive fill in the blank seems like an issue that most people haven't thought feasible and haven't wanted to touch. To your question about state forces and state legislation, now that said, I do think the federal government could get on the side of thinking about industry practices requiring disclosure of certain information, data about who the intended parents are, who the surrogates are, complying with privacy standards and laws, of course. Where I think there has been underexplored thinking about what a national or federal framework would look like is efforts to open up what's happening by data disclosures and requiring information. At the state level, it's been very interesting because with the growth of IVF, I think there's also been cultural differences of thinking about the normalization of fertility services, and not as commodified services, but as part and parcel of a set of reproductive decisions that people make. Now, I think that's also interesting because they're really expensive. And we might think also that the support for gestational surrogacy also corresponds with not just powerful industry actors, but very wealthy people who are anxious and interested in buying them. And those people tend to have more political power than people who are not wealthy. And so there is, I think, a convergence here in the political climate of support. We might also think again about abortion. So there's been a lot. So you have a state like Louisiana that bans all abortion at the same time that it is explicit of approving gestational surrogacy and IVF. Now, the interesting thing about that, and I'm sorry to talk so long, but the interesting thing about that is the total bifurcation of the two issues. So without getting into too much detail, all IVF includes abortion. It just does. And here's why. Because when you implant several eggs in a uterus, and this is changing, it's now less eggs are implanted in an IVF cycle, but still it's between 4 or 5 eggs are implanted. And if more than 2, typically, of those eggs are fertilized and start to develop as fetuses, your doctor is going to selectively reduce the pregnancy, which is an abortion. But the two things are totally regulated differently, and they're totally thought of differently. And that's in part because of the different industries in which we find ourselves. And so it's a great snapshot into the kind of state forces that have pushed along surrogacy permission, in part because of markets and in part because of influence. Thank you. Ellie.
Hi, thanks. This is super interesting and thought-provoking. I've been thinking about it sort of from a different perspective, and maybe to bring in another body of law, maybe, which is employment. So as you were talking, especially about altruism, I kept thinking about the debates around sex work, and particularly the growing arguments about people using their bodies for sex work being no different than the other ways that people use their bodies in the labor market to earn an income and support themselves. And that clearly is very far from the thinking about this in terms of altruism. But I was wondering if any of those debates have made their way into the surrogacy debates, or whether thinking about it that way and thinking about regulation, particularly of the entities as sort of workplace safety regulation, is a way to get at some of these issues.
Gosh, I love that so much. So much. So I spent a little bit of time in the article thinking about this as an employment issue, because I think you're right. I think that the conversation around sex work has a lot to say about, it's particularly as Ginny noted, in the feminist literature, that where the big debate is like the one in sex work, and there have been parallels drawn about what's so bad about commodification, what's so bad about compensation, particularly if you used a framework, which is what some feminists who support sex work use an employment framework to try to think about the rights of sex workers or gestational surrogates as compensated individuals for a service. And that's the big debate, is that, is it inherently commodification and thus exploitation, which leads to subordination, or can you think about it and can you create the conditions in which you don't presume there's a lack of agency on the part of the surrogate or the sex worker? And I think those conversations have been incredibly helpful. I'm thinking of the work of Kila Shamir, who's written about sex work as an employment and incorporating, just as you say, the ideas from the employment sector about how we might safeguard the interest of people who engage in sex work. The same can be done. And that's a little bit of what I'm trying to do in saying, let's think twice about the altruism thing. What would it look like if we thought of it, if we incorporated more of the language and more of the rhetoric of employment and employment practices in this space? So it's a really great point. Alice.
So this in a way follows up on Ellie's point about talking about bringing in a perspective from another area of law, and I bet you can guess what area of law I'm going to talk about. So there is a case in most tax case books that actually deals with the taxation of egg donation. So this is not gestational surrogacy. But what is interesting to me as I was reflecting on that and the argument made in that case in the context of your talk and the framing of the agency as a sort of matchmaker that is doing a good thing, and the gestational, the carrier or egg donor as someone who's doing a donation, is actually the polar opposite of the argument that was made by the egg donor in this case, which was litigated in the tax court in 2015, in which the egg donor said, I was paid twice for donating eggs, but the money that I was paid was not compensation. It was not personal services. It was rather damages for personal physical injury, which under a provision of the Internal Revenue Code are not subject to tax. And so therefore my fee, because it was a damage, there was a personal physical injury to me in going in there and, taking my egg, it's not taxable. And the way the IRS found out about this, which is a question students often ask, is that the surrogacy agency, the matchmaker who paid the $10,000 that the taxpayer got, sent her a 1099, an information return, which goes to her and goes to the IRS. And so whether she liked it or not, the IRS came after her. The tax court said, no, this is not damages. And the reason it's not damages is because for it to be damages, it has to be a payment for a tort. And since she agreed to be an egg donor, that agreement, the contract basically prevented the physical act on her body from being a tort because it was obviously consensual. So as you were talking, I was reflecting on that, and this is not a question, obviously, but it was just very interesting to me how in the context that this issue had come up within the tax law was so very different from, the framing of something nice.
I love that example because it turns it on its head, like the what would be the benefits of continuing to think about this as not employment, as not a fee, as not a service. Like what do you give up when you give up a framing? And that's a very real material consequence that I think is fascinating. That's a great example. Edith, I saw you had your hand up. Did you want to?
Sorry. Yeah, if we have time, I'll keep it very short. It's a very simple question. I know very little about this topic. I found it fascinating. It sounded to me like most contracts you're talking about are between the surrogate and the prospective parents and not involving the agency that is sort of in the middle, at least relationally. And I was wondering if there is a contractual role for them, because that would not have the same altruistic overlay. That's much more purely transactional, much closer to sort of regular contract law, where there's also less of the sort of one seller, one buyer kind of problem. And I'm wondering if there are any approaches that involve them in sort of an oversight role and having contractual obligations in that way.
It's a great question. And so, intended parents will have a contractual relationship with an agency. A surrogate will have a contractual relationship with an agency, and the agency then forms, helps them write the contract between themselves. And you've hit the nail on the head for me which is, I think echoes some of the comments made before, is that the statutes presuppose that the only relationship that matters are the intended parents and the surrogates. Like that's the only thing that we should try to regulate, not the other contractual relationships and the way in which the agency is an intermediary. But you could imagine, back to the point about Paul's point about frameworks, about federal frameworks or state frameworks, you could imagine legislation or regulations or something that does think about the relationship as intermediaries, does apply standards or ethics or guidance or the like that could be done through professional organizations, which already are part of this conversation. Or you could think about the development of case law around agency principles for what agencies, agency principles for how agencies have obligations and duty vis-a-vis both intended parents and surrogates. And there's some case law out there around that, but it really involves very egregious negligent behavior on the part of agencies, but it hasn't been developed as a source of, in terms of regulatory templates for how we might think more specifically about the role of agencies in these contractual engagements. So it's a great observation. So we're out of time. Josette, I saw you had your hand up if you wanted to take the last word, but no pressure.
Oh, no, I just, very interesting topic, and how law is still catching up with technology. And I wonder if you have seen yet, because Dobbs is only a year old, if you think that's going to affect contracts, especially in conservative states, especially with selective reduction and, the Christian right and the conservative and the backlash against, culture and everything like that. That was one of the things, you see Florida having all this book bans and stuff like that, but yet, like in Louisiana, you have a full abortion ban, but yet you still have selective reduction. So I don't know if you saw anything in the contracts coming out, if that Dobbs has been reflected yet.
Right. No. So I think what's happening is, because the industry has really moved to be very national, that groups are relocating to states without bans, is one thing that's happening. The other thing that's happening are these provisions that say in compliance with state law, whatever that means. And then I think I think this is unfortunate, this willingness to bifurcate abortion post-Dobbs from everything else related to assisted reproductive technology. And I think we will start to see definitions as they react to changes in the political, practical, legal environments, state provisions that either explicitly accept certain assisted reproductive technology practices or IVF or the like, or define abortion differently so that it imagines the pregnant person, not prenatal genetic testing, not embryo selection outside the body. I think it's going to be an increasingly complex terrain. Well, thank you all so much. I really appreciate you spending the hour listening to gestational surrogacy. And again, I'm very honored to receive the Friel Scanlan. I'm very appreciative for it.